he'll attend in a little bit, but I think we have everyone, right? You think that's right, Max?
I think so, other than Douglas, it looks like.
All right. Well, thanks. Okay. Well, thanks everybody. We got an expert that's going to help us stay out of trouble. Adam Lovelady with the UNC School of Government is here, and I look back at some old notes, and it looks like we had Dave Owens here back in 2015. So it's been a while since we've had this training. So yep, here he is, and I'll just turn it over to him, and we'll go from there.
Sounds good. Thank you very much. I'm going to start talking, and if you can hear me, if I can just see a thumbs up, just to make sure that I'm not just talking off into the interwebs. Excellent. I see enough thumbs up to think that at least most of you can hear me. And I've got some slides that I'm going to share in just a minute, but let me just start with a couple of general comments. First off, it is a strange time to be in public service and government in America. And I just wanted to say thank you to all of you for your public service, your willingness to show up on whatever, I don't know, the first Tuesday of the month. I don't know what your specified day is, but to do work for your community in such interesting times. Thank you for that. And I want this session to be helpful for y'all. And so I've got some slides I'm going to go through. I've got some topics that I think we need to cover, but I want to make sure that it's answering your questions and then it's serving your purposes. So as we go through, I would welcome your questions. If you want to throw those into the chat box, that's fine. I can check that on occasion, or if you want to just jump in and interrupt, I can do that too. So whatever makes sense for y'all, however is best to handle it, I'm fine with that. So let me see if I can share my screen here, and you should then get to see the first of the slides, quasi-judicial decisions and the Board of Adjustment. And I sent to Max yesterday a notes version of these slides, and I think those will be available to you. You may have already seen those, but just for future reference, you will have these slides available. I'll also point out to some other reference documents that may be helpful, probably more helpful than the slides themselves. So I'll reference those as we go. All right, so just a quick background on me, just so you know who is this strange talking head that's visiting in on this Thursday morning. I went and did my undergraduate degree in history and religious studies at Auburn University, and then I spent some time working. I did a year working in historic preservation, splitting my time between research work in Asheville as well as working for the Uptown Shelby Association in Shelby, Cleveland County, just a couple of counties over from you there in Charlotte. After that, after my work in historic preservation, I went back to Atlanta and taught second grade. It was the hardest job I'll ever have. It was also perhaps the most rewarding job I'll ever have. It was an amazing experience. From there, after 2 years teaching, I myself went back to school and got a dual degree in city planning and law at the University of Virginia. I was then in private law practice in Virginia, based out of Richmond, but working all over the East Coast, working in land use law and environmental law, sustainable development, and those types of topics. And then 8 years ago, I had the opportunity to come here to Chapel Hill to work at the School of Government. And some of you may know the School of Government, some of you may not, but just to give you some context for who we are and the work that we do, we are a school at UNC Chapel Hill. And we do have a master's program, Master's of Public Administration program. So we have some traditional classes and academic work that we do. But much of our work, and almost all of my work, is outwardly focused from Chapel Hill, working with state and local governments, folks like you, to help with technical advising, to help understand the legal framework for what local and state government can and can't do in North Carolina. I've got colleagues that cover a whole range of topics, policy to elections law to public management, to kind of all the things that government does. For me and my close colleagues, we cover land use law, topics like zoning and subdivision, historic preservation, helping communities like Charlotte understand what's the legal framework, what are our policy options, and what are some of the pros and cons there. We are specifically nonpartisan and non-advocacy, and so we're not in a position of saying, hey, Charlotte, this is what you ought to do. This is the best path for you to go forward. But we are in the business of helping understand, here's the legal framework. Here are the options available to the city. Here are some considerations to take into account for your community to make the best policy decisions for your citizens in your community. That certainly would be different than a small town in Eastern North Carolina or a county in the mountains. And so one of the real joys of this work is I get to work with the whole range of North Carolina. It's a big, diverse state, lots of different things going on, lots of different policies and priorities across the state. That's my work. I will note I'm also joined today by my colleague Jim Joyce. He's just listening in, joining in, and making sure that I don't get too far off track. And in case you're wondering, who's that new board member that's also on the call? Jim is my colleague that's going to participate along and listen in. All right, so I mentioned some future reference documents. One is a handbook that another colleague, David Owens, and I put out a couple of years ago, the quasi-judicial handbook. Y'all may well already have a copy of this in the office, or you as board members may have copies of these. It is intended as a reference book, a guidebook to help board members and staff that are staffing quasi-judicial boards to understand the legal framework, to understand the steps of the process. It includes some analysis and description in the first few chapters, and then it's also got reference kind of appendices in the back, including a sample script for a chairperson to go through a quasi-judicial meeting, sample orders and decision documents to just get a sense of what are the different types of decisions and documents that might go along with quasi-judicial decision making. I'll also note some specific statutory references there. 160D is the new recently rewritten chapter of the North Carolina General Statutes. 160D is now where all of the planning and zoning authority comes from. It used to be kind of scattered around, and there used to be a municipal version and a county version. That's now all consolidated into 160D. And the specific guidance and rules around quasi-judicial decision-making, the specific guidance around variances and appeals from staff decisions, those topics are handled in those specific sections of 160D. So I wanted to highlight those more for the staff and the attorneys than the board necessarily, but certainly board members knowing where your authority comes from and what that framework is can be helpful. I'll also note the Coates Cannons blog, which is a blog that colleagues and I at the School of Government have been contributing to for the last, I guess it's been going for about 10 years now. But it serves as both a way for us to post new and kind of breaking information, breaking news, and new cases, new statutes, that sort of thing, and explain the impact of those. It also serves as a great repository of kind of the work of local government and the legal rules around that. And so it can be a really good place to start if you're wondering about a specific question of how do we handle this? Can we consider that evidence? How do we handle standing for this quasi-judicial hearing? Coates Cannons can be a great place to start with some of those questions. It's searchable. You can kind of filter it by author and kind of zero in on the topics that you need. So I just wanted to highlight those resources. All right. So for our time together this morning, the way I've kind of broken down the discussion is first off just going through some of the quasi-judicial procedures. And talking with Max ahead of time, it sounds like for some of you, you're relatively new to the board, and quasi-judicial procedures, I will be honest, they're confusing to those of us who deal with it all the time. And so especially for those that are new to this kind of realm of decision making and this type of decision, it's helpful to get some framework of what is this type of decision and what are the due process requirements that go with it. And I'm sure that some of you have been on the board for a while and you are expert in judicial decisions. Even so, I know for me, a refresher from time to time is helpful, and I'm hoping it'll be helpful for you as well. Then after kind of laying the foundation of the framework of quasi-judicial decision-making and the procedures that go with it, I want to spend a little bit of time looking specifically at the variance standards. They're set forth in state law, and when you're making decisions on variances, you've got to make certain findings. There has to be evidence to support that, yes, this applicant meets these specific standards. And so I want to look at those standards and also consider evidence. What's some evidence that's good that we can consider? What's evidence that is out of bounds for us and we just don't even need to worry about it, even if we wish we could? What are the bounds of the evidence that we can consider or not consider? And then finally, spend a little bit of time on appeals of staff decisions. One of the duties of the Board of Adjustment, one of the things that you are called to do is when there is a decision made by administrative staff, a zoning permit is issued, or notice of violation is issued, or there's some interpretation of the ordinance made by staff. If there's a party with standing that disagrees with that decision, they can appeal that staff decision, and that appeal goes to the Board of Adjustment. There are certain rules around how that's handled. And oftentimes it comes up with questions of interpretation. And so what I want to do is spend a little bit of time looking at those specific rules, the procedures for those appeals, but then also some general guidance on how do we interpret the ordinance? What are some rules of thumb for interpreting this local law? So those are the topics I'm going to cover as we go through. Sitting at any point from 9 to noon is a long sit, and so we'll definitely take some breaks. But sitting through quasi-judicial procedures from 9 to noon can be especially trying. So we will. I'll take a break at roughly each hour, depending on how long-winded I get and how many good questions you're asking. But we'll definitely take some breaks as we go in between these sections. I've also got a few just little examples or discussion questions for us to take a look at for each of these sections, just to kind of think about how this plays out, think about some of the details and what they mean in practice. So those are the topics that we're going to cover over this time. So let me get going with that. And what I'm actually going to do is I'm going to pause the sharing for just a moment and come back just to talk to you, because there's a kind of a framework that I want to set up that is not in my slides, but I think is important for us all to understand as we think about where does quasi-judicial decision-making fit into all of this. So I want to talk about 3 different types of decisions that local governments make around planning and zoning. So on one end of the spectrum is the decisions that city council makes, legislative decisions. They are the local legislature setting laws and policies for the city. Those are broad policies. They apply across the city. It's things like amending the zoning ordinance or the Unified Development Ordinance. It's things like, I know Charlotte's going through the process of updating the UDO. When that whole new UDO is adopted, that's a legislative act by the local legislature, the city council. And that legislative act, it's got certain procedures that go with it, but it's also got some broad discretion. Our local politicians can make the decision that they think is best and in the interest of the community based on the politics, based on their personal preferences, based on their vision for what the city ought to be. Now, there's limits. It can't be based on race or religion or creed. It can't be based on some grudge against an individual. There certainly are limits in the discretion, but they're pretty open to make the decision they think is best for the city when they're making legislative decisions. So that's one end of the spectrum. At the other end of the spectrum are the administrative decisions, ministerial decisions. Those are the decisions typically made by staff, and those are decisions that are taking those broad legislative policies and actually putting them into practice. Granting that site plan permit. Look, you're reviewing the application from the developer, see, okay, does it meet the setbacks? Does it meet the height requirements? Is the parking, is the parking designed appropriately? Can they handle the stormwater? Technical analysis based on objective standards and granting that permit. It's an administrative decision. It's based on objective, clear guiding standards. There's not a lot of discretion there. The site plan either meets the setback. I get up my ruler. It's either 30-foot setback or it's not, and there's not a lot of discretion needed. It's not, my personal preference doesn't come into play. So we've got broad discretion on the legislative side of things. We've got very little discretion on the administrative side of things. clear objective standards. In between those two, kind of in this continuum of decision making, is quasi-judicial decisions. Quasi-judicial decisions are based on standards. It's not the wide, broad discretion that the legislature has. There are clear standards in place, and we're going to talk today about the standards for variances. If an applicant wants a variance, they have to show up and they have to show, I meet this, I meet this, I meet this, I meet this. But those standards are not clear objective standards. Those are not like get out the tape measure standards. There are things like, is there unnecessary hardship? Well, you can't get out the tape measure for unnecessary hardship. You have to take in some evidence. You have to weigh the evidence and consider, well, how hard is this hardship? How unnecessary is this hardship? And make a determination of, well, has the applicant presented evidence that yes, they meet this standard. Yes, they have unnecessary hardship such that we can grant the variance. And so it's based on some standards similar to the administrative decisions, but there's still some room for judgment and discretion. And because of that, because of the nature of that decision, where we're taking these general standards and applying them to someone's property, we're making decisions about their property rights. We're making decisions about the neighbor's property rights and impacts on the neighbor. Because we're making those decisions, there are very clear rules of due process that come into play. We have to have clear guiding standards so that the general public knows, well, what does it take to get a variance? What is the standard that I have to meet in order to get a variance? There's got to be clear notice provided both to the applicant and to the neighbors so that they know that this decision is happening. Here's the standards that come into play. This is when the meeting is and how to participate in that meeting. There has to be evidence to support the decision. Now, when City Council adopts the UDO, when they make a legislative decision on the UDO, they don't have to point to evidence. They're going to make a political decision about the UDO. Now, given the fact that it's taken a good decade to get it in place, I'm hoping that by the time it gets to City Council, it's in good shape. They're ready to approve it. But they're not going to point to, this piece of evidence in the record is why we're approving that. But when it comes to a quasi-judicial decision, there's got to be evidence in the record to support the decision that's made. We've got to be able to point to, look, this is in the application materials, and this is why we're making this decision. Or this is the testimony that came in for this decision. This is why we're making this decision. Because of the due process requirements, there's extra formality, there's extra evidence, there's extra process that goes along with the quasi-judicial decision making. All right, so that's kind of some framework to keep in mind. We don't have the broad discretion of legislative. It's not the clear objective standards of administrative. We're operating in between those, and because of that, we've got to have some care. We've got to be really careful with the procedures that we follow. All right. I'll bring back up my slides to share, and then I want to really dig into, well, what are those procedures? Because we're operating in this quasi-judicial realm, what are the procedures? One of those is just upfront note the notice requirements that go along with a quasi-judicial decision. Before that evidentiary hearing, there has to be specific notice, and the state law requires that there's mailed notice that's going to go out to the applicant. It's going to go out to the property owner if that's somebody different than the applicant, and it's going to go out to neighbors of adjoining and abutting properties. And so the owner, the very close neighbors, and the applicant, if that's someone different than the owner, is going to get mailed notice. There's also going to be a sign posted on the site to let passersby know, hey, there's a meeting coming up about this property. And if you have a stake in this, if you have an interest in this, you may well want to participate in that meeting. Now, those are the two things, the mailed notice and the posted notice. Those are the two things that state law requires, but your local ordinance can require additional notice. And so some communities will say, well, it's not enough to mail notice to just the adjoining properties. We need to mail notice to any property within 500 feet or within 1,000 feet. And that's a choice that you as a local community can make, but it's not required by state law. Similarly, some communities say, if this was a rezoning, we would post notice in the paper. And some quasi-judicial decisions are very similar to a rezoning. So let's go ahead and we'll publish notice in the paper, to make sure that the general public knows about this meeting. You can choose to do that. You can add that to your procedures or to your ordinance, but it's not required by state law. Now, once you've got rules in place, once you have added to the state requirements, then you have to follow those. And so if the city has said, yes, we're going to mail notice beyond just the adjoining properties, we're going to mail notice out to 500 feet, then the city's got to actually do that. And if you fail to do that, then that can create a procedural hiccup that could then the decision could be challenged down the road. Now, when there's an evidentiary hearing, when we've got a hearing on a variance or we've got a hearing on an appeal of a staff decision, as I said, we're all about gathering evidence and basing the decision on evidence. And the evidentiary hearing is all about gathering evidence. But even before we get to that, there's going to be some evidence that we take in as a board. The application or the appeal is submitted to staff. That's if we've got a good application form, it's going to have a lot of good information that we need to base the decision on. Where's the property? What's their claim of unnecessary hardship? Do they have standing to appeal this decision? We need to set up our applications to make sure that application is requesting the information that we need in order to make this decision. There's also going to be some staff analysis oftentimes to go along with that application. Staff analysis of the ordinance requirements, of the technical analysis, does it meet certain standards? Certain city departments may well contribute to that technical analysis. And then there's also the opportunity for site visits. And that can, in some cases, a site visit by a board member can be appropriate, but you need to be really careful with those. And different cities take different approaches to site visits. I'm not sure about Charlotte's specific policy, but let me talk about some of the pros and cons of different approaches. On the one hand, if we're talking about if we're talking about a variance and a property owner saying, look, my property is very unique. The topography of this lot is really like it's different than anybody else. Well, you know, going out and driving that road, seeing that site could tell us a lot about, well, is this unique to this property, or does everybody on the street have the same issue? It could give us some really useful information for making that decision. At the same time, going out and doing a site visit raises lots of questions. One question is, do you have permission to be there on that property? Is it a safe place to be on your own, poking around, wandering on somebody's property? Also, if you're there, there's a high chance that you are bumping into the owner or the neighbor, and there raises the risk of ex parte communication. Something I'll talk about in a minute, but it's chatting with the neighbors outside of the hearing, chatting with the developer outside of the hearing, which raises procedural concerns. Not only that, but if there's enough of the board that shows up to the site visit, you're there together, we've got a public meeting. We've got to publish that. We got to give notice of that. We got to invite the press, invite all the parties to come along for the public meeting here on the side of the road. Now, that's doable. You can do that if you want to, but you need to be aware of those risks that go along with it. One of the ways that this is oftentimes handled is rather than the board going out to do site visits, having staff go out and take the pictures, gather the information that's needed for that site visit to give some context. All right, so there's some initial evidence that comes in before we even get to the board, even get to the hearing. Now, before we get to the hearing, another thing that needs to be considered is whether or not the board member is an impartial decision maker. Now, the name of this decision type, quasi-judicial, like a judge. This is like a court decision. And in the same way that we expect our judges to be impartial decision makers, to not be biased toward one side or the other, to approach it as a third-party arbiter of rights, we expect the same of our quasi-judicial boards, that they show up open to hear the evidence, open to weigh the different evidence, and make a decision in an impartial way. So a board member cannot have a fixed opinion that is not susceptible to change. Now, that doesn't mean that you shouldn't review the materials. When staff sends out that application packet or that meeting packet, you absolutely should review the materials, go through the application, the staff report, consider and weigh, well, I think this will probably get approved, or I think this probably won't get approved. You can have reviewed materials and started to form an opinion. What you can't do is have already made up your mind. You can't have already decided this is, because that's my old high school nemesis and I don't like him, I'm not going to approve this variance. Or alternatively, because we need new development in this area, I don't care what the evidence is, I'm going to approve that variance. You can't have already made up your mind. You need to be open to hear the evidence and base the decision on the evidence. Another consideration that's useful to do before the hearing, before we get to the evidentiary hearing, is there a conflict of interest? When it comes to quasi-judicial decision-making, there's a few factors that come into play. A board member cannot have a close familial, business, or other associational relationship with an affected person. And so that would be the applicant. You could, if it's your sister that's the applicant, you need to not be part of the decision-making. If it is your business partner who is the next door neighbor who's opposed to this, you need to not be part of the decision making. Similarly, if you have a financial interest in the outcome, if this is your property, you are not. You're an applicant. You're not one of the decision makers. You'll need to step down. Now, conflicts of interest are there's always gray areas around conflicts of interest, and we could spend our whole morning kind of coming up with scenarios of, well, is this a conflict? Is this conflict? Is this conflict? One of the things to keep in mind is it's always specific, and it is helpful if you think there's a conflict, raise that with staff and with the city attorney's office ahead of time to evaluate, well, is this an actual conflict or is it not? If it is, then you will need to recuse yourself from that quasi-judicial decision, from that evidentiary hearing. Step down from the dais and not participate in the questioning or the deliberation or voting. Or it could be an apparent conflict of interest, something that needs to be flagged and say, hey, look, I know the applicant from years ago, but it doesn't rise to a conflict of interest. And I can approach this as an impartial decision maker. Just wanted to identify that and put it on the record. And either way is totally fine. But it's good to be clear about that up front rather than trying to scramble last minute to figure it out. A related piece to keep in mind before we get to the hearing is ex parte communication. These are the contacts with one of the parties outside of the hearing. And that might be the applicant. It might be the neighbor that's opposing. But you should avoid those communications with those parties outside of the hearing. In the same way that we don't want the circuit court judge or superior court judge taking a breakfast meeting with one of the litigants, or chatting up the defendant at the grocery store. We also don't want our quasi-judicial boards, our boards of adjustment and others, going to the site and having a meeting with the developer to talk about the project if the other parties aren't there to hear it, respond to it, provide their own perspective. There's a couple of concerns here. One is if you're taking in information from one side, that is prejudice. It's a prejudice against the other side, and they're not there to hear it, to challenge it, to rebut that information. Not only that, but you are a board of adjustment, not an individual of adjustment, and so the whole board needs the information. And so if there's a applicant, if there's a neighbor who really wants to provide good information, that's great. We want them to show up to the meeting so that they can provide that good information to the whole board, so the whole board can take that information in. So you should avoid those meetings with an interested party, conversations, phone calls, emails back and forth with those parties. Now, that said, it's going to happen. The neighbors are going to get your email address off of the city website and send an email to the whole board to say, hey, this is why you shouldn't come to the project. they may call, you may bump into somebody at the gas station, at the grocery store, wherever. When that happens, it needs to be disclosed. And you can have a regular point on the agenda for each evidentiary hearing where the chair invites any ex parte communication to be disclosed. And then it can be disclosed, yes, this, this email was sent out to the whole board. I was out to dinner and bumped into an old friend who happened to be the neighbor, and they wanted to talk about it. I invited them to come to the meeting, but we didn't discuss the details. Those communications need to be disclosed so that then the parties can hear that information and respond to it if need be. And also the rest of the board can hear that information and respond to it and take that into their decision-making process. If it's email, I'd recommend generally just forwarding that to the staff to include in the general record, and for staff to follow up with the interested party to say, hey, here's when the meeting is, you should come to the evidentiary hearing. Let them handle those communications rather than you as a board member. All right, I'm about to shift now to talk about the meeting itself. But before I do that, let me pause for just a minute and see if we've got questions about those kind of before the meeting procedures. Notice, concerns about ex parte communication, conflicts of interest. Let me just pause. I'll get a sip of water and you can think about if we've got specific questions on those. I like to think that my explanation was so thorough and clear that I just left you with no questions, but I'm convinced that's not the case. You're just now in a quasi-judicial stupor. So I'm going to move on, but when that question comes, feel free to interrupt and ask. All right. So your board, I suspect, already has kind of its general routine of how a meeting is run, and you should stick with that and follow that. I'm going to go through kind of just a kind of common order, a kind of standard approach. You may approach things a little bit differently. There's no statutory requirement for this order. This is just kind of a way that things might be handled. And this would be, I want to be clear, this would be for each evidentiary hearing. So at one meeting, you may have 3 or 4 evidentiary hearings, and this will be the order for each one of those. So you might go through this order several times through the course of the meeting. But first up, just a general opening. And a few things that I think really need to go into that opening. And this could be coming from the chair or from staff who may be serving as kind of technical staff for the board. But a general description of this particular case and the standards that apply to this case. And the reason I say that is being very clear up front about what is the nature of this case and what are the standards is a good reminder to the board. It's a good reminder to the applicants. It's good, and it may be a good introduction to citizens who have showed up for this case. And this may be their first introduction to quasi-judicial decision making. So being very clear about here's the standards, here's the ways, here's the things that we have to do in order to make this decision is helpful across the board. Also in that opening, it's good to have just a standard routine moment on the agenda, on the script, where the chair invites anyone to identify conflicts of interest or apparent conflicts of interest, to identify any ex parte communication so that can be disclosed. And we make it routine. We make it regular so that it's we avoid the awkwardness of having to raise, oh, well, I knew this guy in elementary school, but I didn't like him then, but I can be impartial. Just make it a routine part of the opening of each case. Typically, then there's an introduction to the case itself. Staff may kind of read the application and staff report into the minutes and give a general overview of this case. What are the details of this particular variance? Then there's an opportunity for the applicant to present their evidence, to make their case. They are a party to this case. They have standing in the case, and they have due process rights, have an opportunity to be heard. to present their evidence, to call their expert witnesses, to make their legal arguments around this case. Now, there may be other parties as well. There may be very close neighbors who are supporting or in opposition to this particular decision. If they have legal standing in this case, they also have a right to be heard. And they get to present their evidence, to call their witnesses, to make their legal arguments. Also, oftentimes, other non-party witnesses, a neighbor from across the neighbor, from down the street, who doesn't have legal standing in this case, but they're interested. They care about their community. Maybe they're the president of the homeowners association, or maybe they're a nearby business owner. They're very interested in this case, but they don't have a legal right to be part of this case. When it comes to those other witnesses, your board can choose to allow them to speak, and most boards do. Most boards say, look, we want to hear evidence. We want to hear from the community to take in this information. So most boards allow that, but as compared to a party, as compared to the applicant or the property owner, they've got rights to participate. The person from across the city who showed up because they care about this issue, you can, but it's not their right. They don't have due process rights in this case. And so allowing those non-party witnesses to present typically is done. And then an opportunity for rebuttal from the applicants and other parties. And then it turns to deliberation. Now, when it comes to deliberation, some boards will formally close the evidentiary hearing and move into deliberation. Others will leave the evidentiary hearing open and deliberate. Either way is fine. There's not a requirement one way or the other. One benefit of leaving it open is if you then need to ask clarifying questions of the applicant, if you need to get some additional information from the neighbor, you can just ask those questions. They can stand back up. We're still in the evidentiary hearing. You can still allow that information to come in. It can get a little bit tricky if we've closed it and we then want to take in additional information, especially if it's something that's going to go across several meetings. If we closed the evidentiary hearing last month and now we're deliberating and we realize, oh, we really need to ask the developer about X. Well, we've closed the evidentiary hearing. The other parties may have not come back because they didn't think there was any more information to be provided. But now we're essentially reopening the evidentiary hearing. So we'd have to be careful about that. We'd have to put out new notice for that, make sure all the parties were there. So either way is fine, but just some factors to consider with regard to opening or closing that evidentiary hearing before you shift to deliberation. And then through deliberation, we start to kind of tease out where we stand and we can get towards a decision. I'll talk through some of the details on each of those as we go. So if you get nothing else from our discussion this morning, I want to emphasize that the decisions you make have to be based on evidence in the record. Competent, material, and substantial evidence in the record. Quasi-judicial decisions are not about how we as board members feel. Quasi-judicial decisions are not about what we think the policy ought to be. Quasi-judicial decisions are about what is the standard that the applicant has to meet, and is there evidence that they meet that standard? And we have to base that decision on the evidence in the record, the standard that's at play. Now, this rule we've had for decades. The courts told us this back in the 70s, that every quasi-judicial decision shall be based upon competent, material, and substantial evidence. And it's now written into the state law. And so it's made plain that when we're making quasi-judicial decisions, it's got to be based on evidence in the record. What do we mean? What do we mean by competent evidence? That's going to be trustworthy, reliable evidence. That's going to be some of the weighing and kind of teasing out that you're going to do through your questioning of the applicant, the questioning of the other parties, is trying to determine how reliable is this information that's being provided. How trustworthy is this so-called expert? Are they qualified to be providing us with this technical analysis? Do they have the detailed analysis to back up their expert opinion. What do we mean by material evidence in the record? Material evidence is going to be related to the standards. And so if we're talking about a variance, we want evidence that relates to the standard of unnecessary hardship. We're going to go through that in the next segment. Very specific statutory requirements. And we care very much about evidence related to those standards. We can't base our decision on evidence that's unrelated to that, about is this applicant a good person? Or do they have rundown properties on the other side of town? We're not concerned with who is asking for this, who's asking for this variance, or who is asking for this appeal of a staff decision. We're looking at the land use. We're looking at the specifics of this property, the standards at play, and the evidence that goes with that. And then finally, what do we mean by substantial evidence? How much evidence do we need to make a decision? It's going to depend on the case, but the general rule is you need enough evidence that a reasonable person would look at it and say, yeah, seems like they meet the standard. Now, that's not all that helpful, I know. That's kind of lawyer talk, or when we start talking about reasonableness, we get into the kind of lawyerly weeds. But it is kind of it's just kind of an average person test. Would an average person look at this case, look at the evidence that's here, and say, yeah, it seems like they meet the standard? There needs to be sufficient evidence to support the conclusion that the board is making. Now, for a simple variance, that may be a site plan and some testimony from the applicant. For a very complex case, that could be boxes and boxes of technical analysis about the infrastructure impacts of this project, or the stormwater calculations that go along with this. Depending on the case, it could be a lot of evidence, or it could be a very small amount of evidence, but it needs to be enough that a reasonable person would look at it and say, seems like this person meets this standard. Now, where the really hard work comes in is when there's some evidence supporting the applicant's request, but there's also evidence supporting the neighbor's opposition. They each have a technical expert that's arguing either way. This one says this is going to hurt property values. This one says it's going to help property values. Or there's competing stormwater engineers saying, oh, this is going to create way too much stormwater, or no, it's going to be fine. It's not going to cause any problem at all. When you've got that competing evidence, that's when it's the hard work of the board to weigh the evidence and decide, well, which side do we believe? Which side is more trustworthy, has convinced us that they have met the standard or not met the standard. So when there's competing evidence, that's when it's time for the hard work of the Board of Adjustment to weigh out that evidence. Alternatively, if the applicant has shown up and the applicant has provided the basic evidence that they meet the standards, here's why it's an unnecessary hardship, here's why it's unique to my property, here's why it's still in keeping with the ordinance. If the applicant has shown up and provided trustworthy and reliable evidence that's related to the standards, and there's enough for a reasonable person to say, it seems like they meet the standards. And the neighbors show up and say, we just don't like it, and we don't like him. They haven't provided any evidence. They can't rebut the applicant's evidence with general concerns or personal attacks or their opinion about whether this is good or bad. In that case, where the applicant has evidence to support their case, to make their case, and the neighbors don't have anything other than complaints, the applicant gets their permit. They have a right to get that permit. When the neighbors show up and they are prepared to rebut the evidence of the applicant, to provide their own expert, to point to the specific shortcomings of the applicant's evidence, then we've got a case and we can weigh that evidence and make a decision between. So let's distinguish a little bit more about what makes good evidence that we can rely on and what's evidence that we need to just set aside, not worry about. First up, because this is a quasi-judicial decision, like a courtroom, witnesses, not just applicants, but any witness is going to be sworn in or affirmed. They need to be providing factual testimony, things that they have themselves observed, documents that they have themselves created or they know the authentication of, specific detailed testimony about this case, this property, and how it relates to the standards. That testimony needs to relate to the standards at play. And as I mentioned, at the start of your evidentiary hearing, the chair ought to outline, here's the standards that the applicant has to meet. As a reminder to the board, it's a reminder to all the witnesses, you need to be talking about these things. Because we not only are we not concerned with the other stuff, we can't base our decision on extemporaneous discussions about this person or the broader city policies. We focused on the standards at play, the land use impacts at play. That testimony, good testimony, can be supported by firsthand knowledge. I'm a neighbor to the property. Each morning I see the traffic backed up on this street. And so additional traffic is going to create a safety concern. Good testimony can be supported by documentary evidence. I'm the applicant, and here is here's the technical analysis that I hired the engineer to do concerning the traffic impacts of this project. In contrast to that good testimony, the things that we can't rely on, the things that we can't base the decision on, we can't base it on unsworn testimony. We can't base our decision on personal opinions, on the developer showing up and saying, this is going to be great. I think it's really pretty. You should definitely approve this. Well, that's an opinion. It's not evidence. We can't base the decision. We can't base a decision on the person or the owner or the residents that might be living in this or occupying this space in the future. This is a question about land use. It's not a question about who's going to be there or who it is that owns the property. We also can't make a decision based on speculation and unsubstantiated fears. And this is a real challenge because oftentimes, whether it's hyperbole or it's political argument or it's the actual beliefs of the community, oftentimes the things that neighbors bring to a quasi-judicial hearing or to any zoning hearing for that matter is fears and concerns about what might be. And they may well be coming from a good faith position of their concerns, but we can't base our decisions off of what a neighbor thinks this is going to do in the future. The traffic impacts, if a neighbor is not a traffic engineer, then they can't speak to future traffic situations. They can speak to the current traffic situation, what they view, what they see each morning, but they can't speak to the traffic impacts for the future. Similarly, kind of vague assertions about, oh, those people are going to live here, and that's going to be a safety concern for the neighborhood. Those are just vague assertions, unsubstantiated fears that this board cannot rely on to make its decisions. And indeed, the chair should be in a position, once the discussion starts to wander into those topics, to just shut it down and move on to the next speaker, or invite that speaker to provide good testimony and facts that the board can rely on. Now, we can't rely on personal opinion testimony from a non-expert, kind of a layperson opinion. But there are situations where we do need opinion evidence, but it needs to come from a technical expert, an expert witness that can speak to that technical matter. Some of the ways that this commonly comes up, questions of property values, we need qualified appraisers to show up, to give us their qualifications, to provide the comps analysis that they ran, and then we can hear their opinion about, is this project going to harm property values or not? Similarly, if we're talking about traffic impacts, stormwater impacts, other technical analysis, If we're talking about other technical analysis, we're going to need to hear from an expert on those things, not just from an interested person. So when it comes to traffic impact, I'm a city planner and lawyer. I can talk about lots of things, but I'm not a traffic engineer. So I couldn't show up to my local board of adjustment and pretend that I can project what the traffic impacts are going to be from this project going forward. All right, a couple more notes on the kind of moving to deliberation and the decision for this project. Then we'll take a break and we'll circle back with some specific questions and topics around the kind of due process considerations. Deliberation, your board of adjustment, you are a public body making public decisions about private property. While it might be nice to retire to the jury room, so to speak, and kind of hash out the details and just come back out with, hey, here's our answer, that's not what boards of adjustment are allowed to do. You have your deliberation in open session. You kind of tease out the details. You weigh the evidence. You may well disagree, and that is perfectly fine. That's why we have boards of adjustment, not individuals of adjustment, to have those different perspectives and make those decisions based on those different perspectives. But that deliberation does need to be in open session. It's helpful, I think, to start that deliberation again with a reminder of here's the standards at play. Here's the standards for a variance, and then focus that deliberation on those standards. Is there evidence to say this applicant meets those standards? The burden generally starts with the applicant. It's on the applicant to say, to prove, to provide evidence that yes, they meet all the standards. As I mentioned, if they provide enough evidence, competent, material, substantial evidence to say yes, this applicant meets the standards, then that burden shifts over to the other side, shifts to any opponents that might be challenging that application. Working through the deliberation, oftentimes you'll start to kind of settle into some consensus around the decision making. But one of the things that has to be done is if there are contested facts. Appraiser A says this is going to help property values. Appraiser B says this is going to harm property values. The board has to make a determination and resolve those contested facts. There may be dispute about whether this is peculiar to this site or not for a variance, because that matters for the variance. And if there are contested facts, it is going to be for the board to make a decision and resolve those contested facts. That will then be framed into a finding of fact that the board will adopt. With those facts determined, with those disputes resolved, we then take those facts and apply them to the standards at play, and the decision pretty much flows from that. If we have made findings of fact that the applicant, and it shows the applicant meets each of the standards for a variance, then they've made their case and they will get the variance. If we've made findings that the applicant, this is not unique to the property, well, even if we think the applicant, if we'd like to give the applicant the variance, if they haven't met those standards, they can't get the variance. So we determine the facts, apply those to the standards, and we get to our decision. There can be situations where conditions might be applied. There can be situations where in order to mitigate the impacts of this variance or this project, there may be appropriate situations for applying conditions, and that is allowed. Although you need to be careful with the conditions, because conditions are not a holiday wish list of things we'd like to see. Conditions are used to mitigate the specific impacts of this project, to bring it into compliance so that we can approve it. So we have to be very careful with those conditions and what's applied. When it comes to voting, for most decisions, it's just a simple majority. But the Board of Adjustment is one of those special boards that for variances, just specifically for variances, it's a requirement that it that the vote be a 4/5 majority. And so there's a supermajority requirement in order to grant that variance. That means it's especially hard to get a variance. And an applicant's going to have to really make the case. They're going to have to ensure that they have crossed all their T's, dotted all their I's, and meet that standard so they can ensure that, that they can get that variance, because even they could even get a majority, but if they don't get that supermajority, they're not getting the variance. For a quasi-judicial decision, there's a requirement that there be a written decision of that determination by the board. Now, that could be drafted as a draft in advance by staff, or it could be drafted after the hearing is done. Either way is fine. But there does need to be something other than just the meeting minutes that identifies the resolution of any contested facts. You need to have your findings of fact, have your conclusions of law. Any conditions that are applied to this need to be specifically laid out within that written decision document that will then be provided to the applicant, the property owner, any other parties that were involved. If and when this decision is challenged, if it gets appealed to Superior Court, the starting point of that case is going to be this decision document. What was the evidence that this board relied on? What were they looking at to make this decision to allow this variance or to deny this variance? And so that decision document is kind of it is a key document in outlining, here is the key information we relied on. Here is how we resolved these contested facts. Here's the conditions that we put into place to go with it. That written decision document, it is going to need to be the written decision document does need to be signed by the chair or another authorized member of the board. But once it's drafted and signed by the chair, it can go ahead and go out to the parties. You don't have to wait till next month to approve that decision document with the minutes. You can, but it's not required to wait on that. And I did just see a chat. I may have missed some other chat, but I do see that y'all have local legislation allowing for variances, which is a simple majority. And so that makes it a little easier and less calculation headaches for the staff trying to figure out, well, does this meet 4/5 or not? So if you've got that local legislation, then yes, you can continue with just using simple majority on the variance decisions. Makes things a little bit easier and makes it easier for an applicant to meet that standard, I'm sure. I mentioned that notice of decision is going to go out to the parties. You can send that out in several ways: email, first class mail, or personal delivery. And the staff's going to need to certify for the record when that's sent out, when that decision is sent out, because that's going to start the clock ticking for an appeal of that decision. Appeals of quasi-judicial decisions, those are going to come 30 days from the effective date, or there's a specific calculation relating to when the decision is sent out if there's not an effective date. If your decision is appealed, that's being appealed to Superior Court, and it's going to be on the record. That means that Superior Court judge is not going to open up a new case and hear from all the parties and take in new evidence. The Superior Court judge is going to look at your decision document, look at the evidence that's in your record, and decide, well, is there evidence sufficient to support the decision that the board made? If there is, great. If not, then it's going to get kicked back to you for a decision that complies with the evidence that's actually there. In addition to looking at the record, the other challenge that may come in is a procedural challenge. Did the board follow the right quasi-judicial procedures? Were due process rights protected? Was there a conflict of interest that may have tainted this decision? Should a board member have stepped down because of a conflict of interest? Those kind of procedural challenges could also come through an appeal. All right. I've got a few questions we're going to run through when we come back together, but you have sat long enough for one sitting of quasi-judicial discussions. So let's take a 10-minute break, and I'm showing actually we'll make it a 12-minute break just to keep it even. We'll start back at 10:15. Start back at 10:15. Okay, y'all, it is, oh, there we go. It's quiz time, which means you need to go ahead and prepare yourself for speaking rather than just silently staring at me. All right, so just a few quick questions here. These, thinking back, I'm kind of taking us back to early in the presentation, many years ago, it seems like now. In the lead up to a hearing, there's some things we can do and some things that we can't do. So let's kind of work through some of those with these questions. Hypothetical variance application is coming before the board, and some board members are doing some things in advance. And I will say I gave these board members names merely based on the letters A, B, and C, which are the question letters. I did not cross-check them against your names. So these are fictitious characters, just to be clear. So we've got this variance hearing coming up, and we're still before the meeting. Are there any issues that are coming up with these situations? And if so, how could they be resolved? Is there an issue? How could it be resolved? So board member Allen reviewed the application materials. He read the staff report, and he drove to the site so the applicant could show him around. Are there any issues here?
Yeah. I'm Deborah Dryden. I'm a board member, and everything's fine until he did the site visit so the applicant could show him around, because unless the people who had something against it were there, then that's not appropriate.
Absolutely. Reviewing the application materials, yes, please do that. Read the staff report. Staff would love for you to do that. That would be great. That will prepare you to be, have good questions, to be ready to discuss the materials. Depending on your policies, site visit, maybe not, but then for the applicant to show him around. Deborah, you're spot on. That's where we will run into trouble. That's ex parte communication, and that's got to be disclosed at the hearing. There's a real risk of that bias, creating bias for this board member. Alan can't show up at the site to walk around the site with the applicant. If we need to have a site visit, then let's let staff coordinate that. We're going to need to have everybody there. We're going to have the applicant be part of that. So here we're worried about that ex parte communication with the applicant. Okay. At a recent Rotary Club meeting, board member Barbara gave a presentation about downtown development. Downtown needs any investment it can get. I can't wait to approve that variance next month, she said. Any issues here?
This is Douglas Wilson, a board member. I would say that because she mentioned that she can't wait to get that variance approved next month, that's an issue right there.
And what's the issue with that?
Well, since she is a board member and she is saying that she would like the downtown development to be approved next month, that puts her in a conflict of interest when she goes to the board meeting and this application comes before her.
Totally. Yeah. She's showing bias, right? Mm-hmm. She has shown, she's already made up her mind on this. And a quasi-judicial board member has to have an open mind, has to be impartial, cannot have already made up his or her mind on that. So yeah, that statement about can't wait to approve that variance next month. Douglas, you're spot on with that one. That's showing bias, and she's already made up her mind. She's going to need to recuse herself from this hearing. Now, one of the things that comes into play here is, that tension between your general personal preferences of maybe you think downtown needs development, or maybe you think this neighborhood needs more protection, or maybe you think, we all have our personal preferences, our political opinions. We all bring all of that with us. It's not like we set it aside. But we have to be very careful about what our role is, right? And so if here the example is Barbara, she seems very interested in downtown development, very interested in the policies and the outcomes of that. Well, Barbara should run for city council, and she should be advocating for specific policies supporting downtown. As a Board of Adjustment member, she's asked to apply the standards as they are. She has to base that on evidence. It's not a political opinion. It's not a personal opinion. It's just an impartial decision maker's view, weighing the evidence and making that decision. She can't have already made up her mind. Great. Next up, Board Member Chris owns property nearby. He met with representatives of the neighborhood to discuss the proposed variance. We got any concerns here?
My concern is that he owns property nearby. So that he met with representatives of the neighborhood to discuss the proposed variance. It gives me pause because he owns property nearby.
So yeah, we've got a couple of things going on here. He owns property and he's meeting with representatives of the neighborhood. Let's take each of those separately. First up, he owns property. We'd want to know how close nearby, right? I mean, is this next door? Is it a quarter of a mile away? Is it a mile away? Are we in a big rural county where it's 2 miles away, but that's nearby? We'd want to know what's meant by nearby. But if he owns the property next door, well, he's got a financial interest in the outcome of this matter. That's a conflict of interest. Chris is going to need to recuse himself from that case. If it's down the street, around the corner, across the neighborhood, well, then we get into those gray areas of conflicts of interest, and we'd want to have some discussions about, is this really a direct impact, direct financial impact, or is it more removed? So on the property, we'd need to know a little bit more detail about how close by. He met with representatives of the neighborhood to discuss the proposed variance. Well, this is a lot like the example in A, right? This is a lot like Alan meeting with the applicant to show him around. Meeting with the neighbors to discuss the variance is also ex parte communication. And we're going to want to avoid that. And if it happens, if there's the email that's sent to you, you bump into somebody, you're going to want to disclose that at the hearing so that that ex parte communication is disclosed. One of the things that you might do in order just to equip yourself and your fellow board members is have that kind of ready elevator speech to respond to the person. I mean, these days with social distancing, it may be there's less opportunities for bumping into people, but in more normal times, what's the response when you bump into somebody at the grocery store? You bump into somebody at the lunch restaurant. You have a business meeting unrelated to the variance, but oh, it's the neighbor that's there at the business meeting, and they want to talk about the variance. I think having just a ready, quick elevator speech along the lines of, I'm glad you're interested in this case. I really want to hear what you have to say, but I want the whole board to hear what you have to say. And any other parties need to be able to respond to that. So please come to the meeting. The meeting is at X date and time. And here's the staff contact that you should talk to about what is a quasi-judicial hearing, because it's weird and quirky and you need to prepare yourself for it. But being ready to respond to those interactions, because they're going to happen, is I think, a helpful thing for the full board. The final example, board member Deborah didn't do a thing. She did not visit the site, and she did not review the application materials or staff report. Deborah, I note that your name is spelled differently. This is a different Deborah, so worry not. Any concerns with Deborah's actions before the meeting?
This is Krista. I would just say you need to be prepared to review the application materials and staff report prior to the meeting.
Yeah. So it sounds like Deborah's ready to roll off of the Board of Adjustment, and maybe she should. Thank you for your years of service. Deborah, D-E-B-R-A, not Deborah, D-E-B-O-R-A-H, just to be clear. There are lots of ways of going about being a board member. It looks like here in example D, this is not the best way of going about being a board member. We want our board members to review the materials, to show up to the meeting prepared with good questions and concerns, to ask of the applicant, ask of the neighbors, to weigh the evidence, to be prepared to evaluate the facts and apply the standards. Now, to be clear, here in example D, there's nothing illegal here. Deborah didn't, this is not a due process violation. It's just an unprepared board member. And so we certainly want our board members to be prepared, actively engaged in the matter. And so it's going to be best to do that, to review those materials and be ready to go. All right. Any other thoughts or questions with regard to Alan, Barbara, Chris, or Deborah with a DEBRA?
I actually have a question, maybe for Shad. I'm a new board member. Do our staff go visit?
Yes. Yeah, we will go out and visit the site and take photographs, and those are part of the presentation that we do before the full board.
So those photographs we see are taken from staff, not being submitted by the applicant.
Correct. I mean, there may be some times where if the applicant provides a presentation, there may be some photographs from them, but in our presentation, it's from our own staff members taking those pictures.
Yeah, and that's a good question, Krista, and important considerations there of who's taking the photos, from what perspective, what's not within the frame of the photo, just across the street or behind those trees, depending on who's taking the picture and what they're trying to present. You can have a very different outlook. Photos can tell a lot, and what's not in the photos can avoid telling a lot. All right, any other questions or thoughts on this before I'm going to shift to the variance standards?
I had a question about the decision letters. It said in the presentation that I clerk affidavit. When I send out the decision letters, am I supposed to be signing an affidavit?
So that's given as an example. What you would want to do is you would want to certify for the record when that's sent out and to whom, and add that into the case file, so that if there's a question down the road of did they get notice, when did that notice go out, how do we calculate the time for appeal, you'd want to have clear documentation of that. And so a standard form that identifies that and that you sign and certify would be fine. Some documentation for the file of here's the decision document, here's when it went out and to whom it went out.
Adam, if I can jump in on this one.
Yep.
So Max, for our actual letters, we have the date in which it was signed by Shad Spencer. And being that his signature is the last one on the letter, that is generally going to be the day that we're mailing it out or the next day. I think that is sufficient for our practice here. I don't think we have to have any kind of notation or any kind of notary aspect to our letters in that regard. Once we send them out, we are typically, again, sending them out by regular mail and certified mail and also by email. I think we are covered in that regard. So I don't think you need to do anything in addition.
Okay. And also, I had another general question. You mentioned a couple times about, referencing property values. It's my understanding that you can't really take financial situations into account when making decisions. How does something like property values play into that?
Yeah, that's a great question. So a couple of things come up with that. One is much of the case law and discussion around quasi-judicial decision-making relates specifically to special use permits. And for many communities, one of the standards for a special use permit is that it not harm neighboring property values. And so for many quasi-judicial decisions, special use permit quasi-judicial decisions, there are appraisers, there are debates about whether this is going to harm or help property values. And so that comes up in the case law and in the discussions a lot. And so that's part of that is me pulling from general quasi-judicial training that also applies to special use permits.
And Adam, let me just jump in here for that. in the context of Charlotte, we do not issue special use permits or conditional use permits at all. Our board is very narrow in the sense of just doing variances as well as appeals. We do conditional zoning in the city of Charlotte. So I just want to make sure when you're speaking about permits, I think you're talking more of the aspect of conditional use permits and special use permits, not necessarily a variance permit, so to speak.
I'm talking specifically about special use permits that are quasi-judicial in North Carolina. Sounds like Charlotte's not doing any of those. I know y'all do most and maybe all as conditional zoning, which is a different set of procedures and beyond the scope of this presentation or this board. But the broader notion of when there is a technical question for the board to take on, and they need technical analysis, that's got to come from an expert. In other communities, when they're talking about property values and special use permits, they need actual appraisers that are qualified as appraisers to run that analysis. In the context of a variance, there might be a question about stormwater impacts. There might be a question about traffic impacts. There might be questions about any number of other technical analysis, and you would need the applicant would need to present expert to provide expert opinion about those technical matters. And the neighbors couldn't just show up and say, we don't believe that. That's hogwash. They would need to actually have an expert to speak to those matters. Now, Max, a separate question that comes in with regard to property value and just the broader notion of economic means and cost. We need to be careful. The starting point and ending point is this is a question about this property. It's not a question about this property owner. And so the fact that the applicant is super rich and they could pay for this if they want to does not factor into should they get a variance or not. The fact that the property owner is on a fixed income and has limited means does not come into play with do they have evidence such that they should get the variance or not. The questions of the variance, and we're going to go through right now. Is there evidence they meet those standards? That is the question. It's not about whether they have the means to pay for this or not. Now, a related piece to that is, what is the cost of complying with the ordinance? How much is it going to cost to actually adhere to the ordinance? Or in contrast, how much could I save if I got the variance? That can't be the start and end of the discussion, but I think one measure of how hard is this hardship is how much does it cost? That's one measure of how hard is it for me to meet this. Now, let's say there's a requirement to have a paved driveway, and I approach the board to say, hey, I think I should be able to put a crushed gravel driveway because of the special topography and lay of my lot and because of the soils of my lot. As compared to my neighbor, I would have to spend an exorbitant amount more than my neighbor to put a concrete driveway. But if I could do crushed gravel, it would be substantially better. I think that cost analysis could come into play as one of the factors of how hard is this hardship. But that's not the start and end of it. There's still the question of, well, is that the fact? Does that apply to all your, like, is it everybody on my street? Everybody on my street would have to pay that much. In that case, it's a shared burden. It's not unnecessary. That's a shared burden for all. And so that cost of compliance, I think, is a factor. It's not. I don't think you have to set aside that piece of it, but it's not the start and end of the analysis. And it doesn't. You can't then step forward to, okay, compliance costs this much. Does this individual have the money to pay for that compliance? That's beyond the scope of the variance. Okay, that's a great segue for us to then jump into the standards for variances. So let me walk through those. And the standards for variances are outlined. They've been in the statutes for several years now and are now at 160D 705. This is set forth in state law. And unless there is some variation through local legislation for Charlotte, then these are the standards that an applicant has to meet in Charlotte in order to obtain a variance. I'm going to now look to some of y'all through the chat box or just to unmute yourself. Does Charlotte have local legislation to alter the state standards for variances?
Adam, we do not change the requirements for the variance standards. The only legislation we have, as Chad indicated, is the vote requirement was lowered from 4 to 3. Everything else is in conformance with the state statute.
Got it. All right. That's helpful because I don't want to spend 30 minutes talking about variance standards that don't apply to y'all. Okay. So variances, when unnecessary hardships would result from carrying out the strict letter of a zoning regulation, the Board of Adjustment shall vary any of the provisions of the zoning regulation upon a showing of all of the following. So we've got these next few slides are the standards that the applicant has to meet to show they have unnecessary hardship. Now, I want to be real clear here and straightforward about this. This is about unnecessary hardships. Look, regulations are all about hardship. We all are subject to regulation. All of our properties are subject to regulations, and it's shared hardship. I and my neighbors have the same regulations, and some of it I might think is unnecessary, but it's shared across all of it. The question for a variance is this particular property, because of the unique circumstances here, is it overly burdened by this regulation such that we should relax the rules for that one property? This is not a policy question of should we have different regulations? Should everybody have less hardship or more hardship? Again, if we think there ought to be a change to the rules, well, let's talk to city council and get the rules changed. If everybody thinks the driveway standards ought to be different, let's change the driveway standards. Variances are not about changing policies. Variances are about relaxing the rules for one specific property because the regulations are unnecessarily onerous on that one property. So,
Adam?
Yeah.
May I ask one question?
Yeah.
To help kind of frame this for the board. You emphasized several times about one person. If a applicant or property owner is coming before the board and other people are similarly situated, so it's just not that one person, it could be two or more that all have the same type of circumstances, does that defeat the need for the variance, or as you indicated before, push this towards a legislative change versus a variance being granted?
Yeah. So it's a great question. It is specifically, let me see here. All right. I'm jumping. I'm gonna do the second standard first, and then I'll come back to the first standard.
I apologize if I was getting you ahead of your
No,
presentation.
it's fine. I mean, this is exactly what I was talking about. In order for a variance to be appropriate, it's got to be peculiar to that property. The hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. I'm gonna get that last sentence in just a minute. If this is a variance where we've got 3 or 4 folks on the agenda for the same variance, if this is a variance where we granted one last month, we've got one on the docket for next month, and here we are again doing the same thing, well, that's a situation where we need to be talking about the broader policy and do we need a change to the broader policy? If it is a hardship that results from conditions that are common to the neighborhood, well, then we need to be talking about changing the rules, going to for a legislative decision from city council to adjust the setback or adjust the driveway requirements or whatever the common variance is. Now, that said, Charlotte's a big city, and there's I'm sure lots of unique properties that are unique in somewhat similar ways. And so the mere fact that you have similar variance requests doesn't necessarily mean, well, we have to say no to all of these because they're relatively similar. But if there's a pattern, if it's clear within this neighborhood, everybody's seeking a lot size variance, or on this street, everybody is seeking a setback variance, that's then speaking to there's a broader legislative change. So given the size of Charlotte, I don't want to say that merely because we have had a request in the past, we now have to deny every other one going forward and just push it to city council. There may be situations where there are similarly situated properties that need a variance. But if it's recurring, if it is something that's common to the neighborhood, common to the public, that doesn't need a variance, that needs a legislative change to the zoning ordinance. Thomas, I'm going to pause there and see if I answered that question or if we need to dig on that one a little bit more.
You answered the question from my perspective, but I want to make sure I emphasize for the board that very aspect. When you're looking at and evaluating variances, this is the one versus many situation. If it's just that single person is the only person affected in a way that no one else is affected, that is where, if you're looking at the standards, it is going to lean towards that property owner more than, denying the variance. But if it's a situation where everybody's affected, then as Adam's kind of alluding to, that is not a basis for the board to really use this person's unique circumstances to grant the variance, because as Adam indicated, variances are supposed to be exceptions to the general ordinance. So we're basically saying that the ordinance is, did not anticipate this unique set of circumstances as part of the overall broad discussions that the council, SHAD, and the zoning staff, inputs from the community, that this one particular circumstance was never contemplated at all. And we're giving them a release valve to exempt them from that one particular requirement in this one particular instance that should be kind of almost, not saying Powerball level, probability, but it should be something that is just a very rare occurrence overall. If it's frequent or reoccurring or similarly occurring in a neighborhood or the city as a whole, then that's where I would recommend to the board, if there's a situation where you're seeing this and you think this is something that's popped up repeatedly, it should be something you direct to staff and then have staff direct to the department head for a potential review of the ordinance to change this, so it is not incumbent upon you to continually issue variances, but for the city to correct this ongoing problem, in our jurisdiction. So I just wanted to say that, Adam, and I appreciate your time in that regard.
Yeah, I think it's an important point. And it's worth emphasizing that puts the board in a difficult position. You're going to have a very sympathetic applicant show up. They may well have limited means. They may well have a very nice case and argument for why they ought to get the variance. And all of their neighbors will have the same very sympathetic argument for why they should get the variance. And unfortunately, based on the state law, based on the purpose of variances, the board is not in a position to grant that variance. The board is in a position to highlight that for staff and for city administration and city council to make those changes for that sympathetic case that's across the neighborhood, not just on this one property, which is part of the hard job of the board, to distinguish those different generalized concerns versus the specific unique concern where variance is appropriate. I do want to highlight here, and I've got a question that goes along with this for Shad or Thomas. The starting point here, and y'all notice I've changed over so I can highlight some of the language. part of the limitation on granting variances, it cannot be based on personal circumstances. And so just because it's a retiree on a fixed income and it's going to be, this is going to be expensive, that doesn't play into the factors of granting a variance. The personal circumstances of that person cannot be the basis of us granting a variance. Now, the one exception to that, and this is where my question comes up, there is now allowance that, to the extent required for the local government providing reasonable accommodation under federal statute, there is an allowance for using the variance process for that reasonable accommodation, which will be specific to that person. And different communities approach that different ways. Some say we're going to treat that as a variance. Others have separate processes to handle reasonable accommodation. And I'm just curious, if Charlotte has other processes for reasonable accommodation, then this board doesn't need to worry about that. And this board can just say, we don't do personal circumstances.
So Adam, to your question, this board is charged with handling the reasonable accommodation. It has been a very infrequent situation, to the best of my knowledge, in the years in that regard. But I definitely want to say that it has come to this board in the past, at least once to my knowledge, where they have had to handle the Fair Housing Act type of situation in that regard.
Okay. And so there the general notion is we don't need to consider the personal circumstances. That's not the basis of our decision. But there can be specific limited circumstances where under federal statute, the local government has to give reasonable accommodation to someone because of their personal circumstances, oftentimes related to specific disabilities. And so that might come up where someone's asking for some relief to the driveway standards so that they can have their accessible van parked and be able to get in and out of their accessible van. It could come up in a situation where someone needs a ramp in order to get in and out of their home, and maybe that needs to go into the setback. Those situations can come up. They will be unique and limited, and it sounds like infrequent for this board, but there can be those limited circumstances where personal circumstances might come into play, but you just want to be clear up front as to when that comes into play and when it does not.
So Adam, let me clarify the ramp issue and those kind of things. I think Shad, you may want to weigh in whether or not you do or do not have immediate authority to kind of take care of that. When I was meaning infrequent in regards to the reasonable accommodation, I am thinking the broader halfway houses, those type of situations, which that reasonable accommodation will have to come into play. But the ramp issue, I can't recall we have maybe those cases on a regular basis. So Shad, you may want to weigh in whether you have inherent authority to approve that without the board, or does that come to the board where we do explain that as why we have to do it?
No, and you're right. What we do for handicap accessible ramps is the zoning ordinance gives delegated authority to staff to approve those as long as, they're meeting, the requirements that they need. And then, like you said, the other reasonable accommodation hearings that we've had before the Zoning Board of Adjustment, the only ones I'm familiar with are those sober living homes where, it's a group home. And so they want to exceed our 6-member or individual cap. And so they go before and do a finding of fact, and we go through that process.
Got it. So these are going to be infrequent, and the board can be prepared in advance of that as to the specific requirements and the unique circumstances of that.
Yes, sir. We do emphasize for those sober living homes that this is a different type of hearing. So they are ideally prepped to understand this is not just a typical variance, but there are implications of federal law in that regard. So we do try to walk them through all of that. To your question, Adam, to make sure they're fully aware that it's just not the city's ordinance, but also federal law. Great.
So then let me circle back to my starting point. Except in those very narrow circumstances and specific hearings where there's separate discussions about it, this board does not need to be worried with the personal circumstances of, is this a unique situation for this property? Is the ordinance unnecessarily onerous on this property? And that brings me back to this first standard for the variance. Unnecessary hardship would result from the strict application of the regulation. It shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. So a couple of really important things for this first standard. The hardship needs to come from the ordinance itself. Some other unrelated hardship that they might have caused for themselves is not a reason for us to then grant them a variance. Just because you messed up over there and kind of caused yourself some limitations doesn't mean we are now obligated to grant you a variance. The variance, the reason for the variance needs to arise from the ordinance regulations themselves. That said, it does not need to be the case. This is the second sentence here. I, as an applicant for variance, I don't have to show up and say, I can't do anything with my property. I just need to show that there is some unnecessary hardship based on the regulations. I might still be able to build. I might still be able to configure some strange building. I don't have to show that there's nothing I could do, but I do have to show that there is some unnecessary hardship. So I don't have to show there's no reasonable use of the property. I just need to show, based on these standards, there's unnecessary hardship based on for my particular property. All right, we talked about that it's got to be peculiar to the property. That really is one of the key factors that comes into play here. No self-created hardship. The hardship did not result from actions taken by the applicant or the property owner. Now, let me stop there. If and when the property owner sells off a piece of the property and changes the setback lines and causes some hardship, well, that's self-created. They're the ones that sold the sliver of the property and changed where the setback lines are. That doesn't then make it our obligation to grant them a variance. If the owner started building without getting proper permits, and now they're circling back and they find out, oh, they built half the building in the setback. Well, that was they created that hardship, and it is on them to find a way for compliance for that. There is some case law around if there was some good faith effort, if they thought they had the permits they needed, or it was the contractor got the permits but then put the footing in the mismeasured the footing. There is some case law around that, but as a general matter, if they caused this problem, some action by the property owner caused this problem, that does not qualify for a variance. That's a self-created hardship. Now, a separate piece to that, the act of purchasing the property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. This basic notion is, if I purchase property and I realize, hey, this property might qualify for a variance. Me purchasing the property is not a self-created hardship. I, as the new owner, step into the shoes of the old owner. If the old owner could have gotten a variance, well, I can also go seek a variance, and just the mere act of me purchasing is not self-created hardship. Now, if I purchase the property and then I do something and I realize, oh no, messed up, let me go get a variance. Well, now that is self-created hardship. Okay, so the hardship has to come from the ordinance. It's got to be peculiar to the property. It can't be self-created. And then we've got some general guidance to make sure that whatever variance is granted, it's still in keeping with the ordinance. The requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. To be sure, this is some broad, kind of flowery lawyer language. But the notion here is, even if we're granting a variance, it still needs to be in keeping with the purposes of the ordinance regulations. This is not just wiping away the requirements. It is adhering to the requirements and recognizing the special circumstances of this unique property. Also, we're not going to grant a variance in a way that creates some public safety concern. we're not going to create a variance in a way that's going to cause harm to the neighbors or cause safety concerns overall. And there's an element of justice within granting variances. The underlying purpose here is we don't want one person to be onerously burdened by this regulation that should be generally shared. And so if this one person, if this one property is overly burdened by the regulations, well, then we should relax the rules for that one property. It's basic justice to make sure that the properties are treated equally. And if one is overly burdened, then we may be in a position of relaxing those rules. So the hardship has to come from the ordinance. The hardship has to be peculiar to that property. The hardship cannot be self-created, and the variance still needs to be in keeping with the spirit of the ordinance and with general public safety and justice. Okay, so those are the standards. If I'm an applicant seeking a variance, I've got to show up and make my case. Here's how this burden comes from the ordinance. Here's why it's unique to my property. Here is, here's confirmation it's not self-created. And here's how I'm still in keeping with the ordinance. I'm not going to cause public safety or harm to the neighbors. There are some additional limitations on variances and specific requirements for variances. There are no use variances. I can't show up to your board with a property that's zoned for residential and say, well, I really, yes, it's zoned residential. I need to put a commercial development on this property, but because of some unique circumstances, my property wasn't rezoned when it should have been, so I should get a variance. That doesn't work. If I need a different zoning category, if a use is not allowed on my property, I need to go to City Council and seek a rezoning for that property. There are no use variances. There can be conditions that are applied to variances. Appropriate conditions may be imposed on any variance, provided that the conditions are reasonably related to the variance. Again, we talked about this a bit earlier. Conditions are not a holiday wish list. Conditions are not a chance for us to kind of pick and grab our favorite new policies and make those requirements on a particular property owner. The conditions are used to mitigate the impacts of this project, to resolve the concerns around public safety, around visual impacts. The conditions are used to make it so we can allow this variance to go forward, but still have appropriate limitations in place. And it's fairly limited. There's not going to be extended conditions going on to a variance. It is always the case that design by committee is challenging at best and often results in a worse project. And so the kind of back and forth committee evaluation of changes to design is always fraught. I would encourage you to be very careful with trying to totally redesign a project as a committee going forward, but there can be applying conditions to mitigate impacts, to make it so the project can be approved. That is allowable and can be used to take care of to get a variance approved and to reduce those impacts of the variance. Okay, so let's go. I want to go through these 4 examples, and then we'll take a break, and then we'll talk a little bit about appeals of staff decisions. So if and when we've got a variance case before us, the applicant and any opponents are going to need to present evidence. They're going, because we have to base a decision on evidence in the record, competent, substantial, relevant evidence in the record. It needs to be sworn testimony. It needs to be fact-based, or it needs to be an opinion coming from an expert. It needs to be documentary evidence. It needs to be very clearly related to the standards. That said, if you're holding a hearing, you're going to get all kinds of statements and evidence, some of which will be completely unrelated, some of which you cannot base a decision on. So let's talk through these and think about whether these are competent and relevant evidence that the board could base their decision on. First up, we've got a petition signed by 10 neighbors opposing the variance. What do we think? Is that competent and relevant evidence that the board could base their decision on?
I mean, I would take it into consideration, but where's their documentation? A petition just signed saying they oppose the variance. It doesn't say why, or it doesn't say how. So I don't know how you would consider that. So, I mean, it would be that extemporaneous, what you talked about earlier, where people can come from, 2 blocks away and share information, but it's not necessarily relevant to, because you can't have 10 neighbors on a plot, within 10 neighbors. So that would be my belief.
We've got some concerns around this one, right?
I do have some concerns.
Yeah. So there's a few things going on here, and Deborah, you raised several of them. One is, this is a petition. These folks aren't even in front of you. And really, for us to take in this evidence to depend on testimony, we need those individuals to show up. We need to be able to ask them questions. We need for them to provide that testimony. These days it's done virtually, but in more normal times, we'd want them at the meeting so we can test their trustworthiness. We can ask them questions. We can read the verbal and nonverbal communication and get that input. So we want folks to show up to the meeting. We can't take hearsay evidence from, neighbor Joe said such and such. We need them here. We've also got some concerns here. Deborah, you point to this. This isn't really evidence. This is opinion. They oppose the variance. Okay, that may well be, but we need evidence. We need facts about why this variance ought not be granted. So they need to show up with some information, not just that they are opposed to it. Not only that, but a petition is an interesting and useful thing in politics and legislation. We're not in the business of politics and legislation as the Board of Adjustment. We are quasi-judicial. We're like a court. And look, when there's a court decision, lots of protesters may show up outside. That does not affect the decision. The decision is based on the law and based on the facts. And the same for a quasi-judicial decision. You've got to base your decision not on how many people show up in matching T-shirts to support or oppose it, based on how many people have put their name on a petition. You have to base your decision on the facts and the standards. It doesn't matter if it was 10 people on the petition, 100 people on the petition, 1,000 people on the petition. It's not a political question. This is a question of standards and facts. Now, we would love for those neighbors to show up to the meeting. We would love for them to have good factual testimony about this project. They might have, if they've got the means and the wherewithal and the time in advance, they might have hired an attorney to represent their interests. They might have hired experts to speak to the technical matters. That would all be good and well. They're welcome to do that. But it's not a popularity contest, not a political question. We're looking for factual testimony to make this decision. All right, next up, testimony from the applicant's pastor stating that the applicant is a good person.
Well, that's wonderful. It's not applicable.
We are delighted that this applicant is a good person. He or she should continue being a good person, and we're glad that their pastor has given them the thumbs up. That's for them to discuss on their own, maybe at their next religious meeting, but unrelated to this project. The fact that this applicant is good or bad, the fact that this applicant is rich or poor, the fact that this applicant is of any ethnicity is irrelevant to the decision-making. It's a question about the property. Does this property, is it unique and needs a variance? All right, next up, we've got a site plan and documentation to show the ordinance is peculiarly onerous on the applicant's property. I should have given myself an easier one to read for this one. What do we think? Site plan and documentation showing that that the ordinance is especially strict for this property.
Well, I think that would be appropriate. They've got a site plan, they've got some documentation. So that could be taken into evidence.
That's exactly what we want, right?
Right, yeah.
That is what we need. And we should make sure that our application and our staff analysis and any other process and documentation is supporting that. We want to get the good drawing, the good documentation, the good arguments, legal arguments for why this should or should not be granted. That's exactly the kind of stuff that we need and want. All right, final one, and then we'll take a break. Testimony from a neighbor about how, if granted, the variance will cause toxic impacts on groundwater and destroy critical habitat.
I don't see evidence. I just see testimony about how, but that's more for the future. I don't know about that one because I want to. Where's the documentation? It just says he offers testimony. That would be his opinion.
Okay, so we've got some concern of lack of documentation here. I agree.
I would say unless the person is actually an expert in those areas, their opinion really wouldn't matter.
Yeah, so I agree with both of you on this one. Exactly. We've got a couple things going on here. If there's a question about toxic impacts, if there's a question about destroying critical habitat, those could be important factors for granting a variance. We talked about that last set of factors. We want to ensure public health and that we're keeping with the spirit and intent of the ordinance. I'm sure that the spirit and intent of the ordinance is not that there be toxic impacts on groundwater. And so these could be factors at play, but there's two really key things going on here, or maybe 2.5 or 3 key things going here. This is testimony from a neighbor giving an opinion. And we can't base the decision on a lay opinion about whether this is a good project or bad, about whether this is toxic or not. If there are technical matters like this, it's going to need to come from, that opinion needs to come from an expert, a qualified expert, who can speak to these technical matters. And it's going to need to be based on some actual analysis, not just, oh, I feel like maybe this might be toxic. And so for this particular evidence, we would need to know, well, is this neighbor qualified? Is this a stormwater, groundwater engineer? Is this a qualified ecologist to speak to the habitat? Who is this person? Are they qualified to be providing this expert opinion? Maybe, maybe not. And then also, on what are they basing their expert opinion? It can't just be, I show up and say, well, I'm a traffic engineer and traffic's going to be fine. There needs to actually be some analysis of what the impacts will be and how that, what that opinion is based on. So on that one, we're going to need some, definitely need more than just a neighbor saying this is going to be bad. All right. So those are some topics of evidence, thinking about things we might consider or not consider with regard to a variance. With that, we have made it through the general quasi-judicial procedures. We've talked about the variance standards and some evidence, some kind of things we might consider with regard to the evidence. Let's take another 10-minute break. Let's start back at 11:20, and I'll talk about appeals of staff decisions, and then we can wrap up with some final questions. So let's start back in 10 minutes at 11:20. See you in a minute. All right, y'all, I'm going to crank back up and shift now to the final section of our time together this morning. But just as a, oh, didn't mean to go there just yet. Just as a quick reminder and refresher. So we talked a little bit about the procedures that go along with quasi-judicial hearings. And those procedures apply whether we're talking about a variance or we're talking about an appeal of a staff decision. There are other quasi-judicial decisions that Board of Adjustment in Charlotte may well not handle, but for other communities, a special use permit is a quasi-judicial decision and has to follow those same procedures. When the Preservation Commission is making decisions about certificates of appropriateness, also quasi-judicial decisions. And some communities handle site plans or subdivisions as quasi-judicial decisions. Regardless of the permit that we're talking about, that set of procedures applies the same. The board is acting like a court. The board has to base its decision on evidence. The board is going to hear from witnesses that are sworn in, that are providing factual testimony and documentary evidence. There are certain standards at play that the board is taking these general standards and applying them to this specific property, this specific project. And the board has to deliberate, weigh the evidence, and make a determination of competing facts to make its decision about whether that project meets the standards or not. Now, we talked about the variance standards. Those are specific, set out in statute. And in order for a property owner to get a variance in Charlotte or anywhere else, they have to provide evidence that there's unnecessary hardship. It comes directly from the ordinance itself. It's unique to this property. It's not self-created hardship, and it's still in keeping with with public safety, with the spirit of the ordinance. And it's achieving justice. A separate process and decision that the Board of Adjustment has to handle is appeals of staff decisions. Those could be appeals of interpretations that staff has made, could be an appeal of a notice violation that's been issued saying that land use is not allowed on that site. Could be an appeal of a permit that was granted, a site plan was approved or a zoning permit was granted. If there was a neighbor that opposed that thought that was improperly granted, then that permit could be challenged and appealed to the Board of Adjustment. Those appeals to the Board of Adjustment, we're still going through quasi-judicial procedures, but they're slightly different in character because of the different position that staff is in for the appeals of staff decisions. So for a variance, staff is serving the board. Staff is a technical advisor to the board and is helping to coordinate the paperwork and to make sure that the application is complete, make sure that all the pieces are there, and help the board along. When it comes to appeals of staff decisions, the staff is there to defend their decision. Staff is there essentially as a party and is providing the evidence and the justification for the decision that they made. And so there's some slightly different dynamics there, but we're still following the same quasi-judicial procedures. Folks are still sworn in. We're still basing our decision on evidence and on the standards at play. Now, when it comes to these appeals of decisions made by the staff under this chapter, that's chapter 160D, shall be made to the Board of Adjustment unless a different board is provided. And so there can be different decisions that are directed to other boards, depending on the boards that you have there in Charlotte, and depending on the types of decisions. But the starting point is if there's an administrative decision that's going to be appealed, it's going to go to the Board of Adjustment. Now, there are specific procedural matters that are set forth in statute and addressed in some of the case law around this. I'm going to highlight some of those, but I'm not going to dig too far into the weeds on those because we could spend all morning on any one of those procedural matters, but I do want to flag them for you for consideration. One is with regard to standing. Who can bring an appeal to the Board of Adjustment? Now, oftentimes it's easy. if I'm an applicant for a permit and staff denied my permit and I want to appeal that denial, well, I clearly have standing. I'm the one who applied for it. If I'm the property owner and the zoning office issued a notice of violation saying I can't have that many vehicles parked on my property, and I think they're wrong, I can appeal that, and standing, whether or not I have a right to appeal it, is pretty straightforward. I'm the property owner, so I've got standing to appeal that. But there can be cases where the question of standing is really key. Does this person that's bringing the appeal, do they have the rights to do that? And the times when that's going to come up, the time when that question really arises is if it is a neighbor who is challenging something that's been done nearby. So suppose my neighbor has too many cars parked on their property, I think, and I called up the zoning office, and they came out and they did an initial investigation. They say no, they meet the standard. I say no way, they don't meet the standard. I looked it up, and this is plainly a violation. You need to give me an interpretation of this as to why you're not granting issuing a violation. And so I get a formal decision regarding my neighbor's property. Well, and I want to appeal that. I want to appeal and say, look, there ought to be a violation, or you shouldn't have granted that permit nearby. Do I have rights to challenge a decision regarding somebody else's property? That's a question of standing. It's a legal question. And there can be times when the board will be called on to make that decision, to make that determination. The factors that come into play with standing, specifically for a neighbor, how close are they in proximity to the property in dispute? Is it the immediate neighbor? Am I down the street? Am I around the corner? So proximity is going to matter. What are the impacts on me and my property? Are there specific property value impacts? Are there secondary impacts like traffic or noise or pollution or dust? Are there impacts on my property and the enjoyment of my property that make it such that my experience with this is different than the broader community? Those questions of standing are technical and legal, and you will benefit if you've got to make those decisions. You'll benefit from some guidance from the city attorney's office and some discussions ahead of time about what amount, what do we need to be looking at. But that question of standing is a question for the board to make. It's not a staff decision to make ahead of time. It is a question for the board to make at the time of starting that appeal. If that person doesn't have standing, you can't handle it. They can't bring the appeal to you. You don't need to worry about the appeal. So the first line of questioning there is, do they have standing to even bring this appeal? A separate procedural matter is timing. When it comes to staff decisions, there is only those decisions have to be appealed within a 30-day period. And if that time period has lapsed, if they have gone past the time period, the statute of limitations has run and they've missed their opportunity to appeal this. And so the question of timing can play into whether or not we're going to hear this appeal or not. There are also technical matters, and really this is more on the staff side than on the board side, but there are technical matters with regard to stays of enforcement. If something is appealed, to what extent might civil penalties be paused? Might other enforcement actions be paused? And there are specific statutory provisions around stays of enforcement while something is on appeal. Now, when there is an appeal of a staff decision, rather than there being the application submitted by the applicant like there's for the variance, here the record is going to come from staff. And the official who made the decision that's being appealed shall transmit to the board all documents and exhibits constituting the record upon which the decision appealed from is taken. The official shall also provide a copy of the record to the appellant and to the owner of the property that is the subject of the appeal if the appellant is not the owner. So if there's an appeal of a notice of violation, the zoning office came out and issued me a notice of violation saying you've got too many cars parked in the front yard. Well, staff is going, if I appeal that, staff is now going to need to compile the record. Here's the provision of the ordinance that specifies how many cars can be parked. Here is here's the photo documentation of the cars parked there on Tuesday, January 5th. And here is the officer's report about what they found, what communications went back and forth. That record will be compiled and provided to the board as the starting record of this appeal. Now, that record can be added to. So through the course of the quasi-judicial evidentiary hearing, the property owner may also have evidence to provide to say, look, here is specific evidence about what's been happening on the property. Here are the permits that we have. Here is our explanation of, or our alternative interpretation of the ordinance as to why this ought to be handled differently. So that record can be added to through the evidentiary hearing, but as a starting point, the official the staff person who made the decision will compile that record and transmit that to the board and to the person who's appealing that decision. Not only that, but the staff person who made that decision, they're going to show up as a witness. They're going to show up as essentially as a party to this case to explain, I went out and did this investigation on this date. Here's what I found. Here's the reason that I issued the notice of violation. Here's my explanation of the steps that we took, the communications that we made, and why we are where we are. If that staff person is no longer with the organization, they've retired, they moved on to a new job, whatever else, then whoever is currently in that position steps in and handles serving as the party and witness to that appeal. From there, it follows the standard process of quasi-judicial procedures. And so you're going to hold a hearing, explain it, an opportunity up front for explanation of this type of case and the standards that apply. An opportunity for the staff person to explain their perspective and their evidence, an opportunity for the appealing party to make their case, to offer contrary evidence. The board will be called upon to weigh that evidence, to make a determination about is there enough evidence of a violation? Should this permit have been granted? Whatever the appeal is, the board will deliberate and decide what is the correct answer. Now, one of the things that oftentimes is run throughout these appeals, one of the things that really is foundational to these appeals is an interpretation of the ordinance. Oftentimes these appeals turn on how do we interpret the specific provisions of the ordinance. And fact of the matter is, legislation is imprecise. Local ordinances, even the longest of local ordinances, and Charlotte has an especially long one, you can cover a lot of topics, but inevitably there's going to be scenarios and situations that don't fit neatly into the language of the ordinance. There's going to be need for interpretation, and reasonable folks can look at the words, look at the scenario, and disagree about how this should be interpreted, how should this be applied to this scenario. What I want to do for the next little bit is just talk about some general rules of thumb for interpretation. Things to be thinking about, ways to approach interpreting the ordinance that the staff person should use as they're making their decision, that the Board of Adjustment should use as they're reviewing that interpretation. And it's the same rules that the Superior Court judge, the Court of Appeals, the State Supreme Court will use as they are evaluating how should this local law be interpreted, how should it apply to this scenario. And I will say, this is the type of case that kind of interpreting the local ordinance is something that makes its way up the courts frequently. And we just had a state Supreme Court case concerning when is a permit issued, how should a permit be, how should an ordinance be interpreted. And it's the kind of thing that's subject to extensive debate, and reasonable folks can disagree on these things. So some rules of thumb on interpreting the ordinance. The starting point, the ending point is the text of the ordinance. we should presume that the governing board knew what they were saying when they adopted the ordinance. They meant what they were saying when they adopted the ordinance, and the text of the ordinance is what it is. We read the text with the plain meaning that's there, and we apply that plain meaning to the scenario, to the situation. Now, there can be times when we realize, oh, that's not quite what we meant in the ordinance. We actually meant that other thing. Well, tough luck. We've got the ordinance that's adopted, and we've got the language that's there, and we're called on to apply the language as it's adopted. If that language needs changing, well, guess what? We're going to city council to get that language amended. And one of the things I think the board should be prepared for, if and when a new ordinance is adopted, there will be lots of improvements in that ordinance, and there will also be little hiccups, little quirks, little things that nobody could have thought about. And the interpretation of that, how it applies to certain scenarios, will wind up on the agenda of the Board of Adjustment, determining how should staff be interpreting this thing. But it's the text of the ordinance that we start with, that we end with. Not what we think it ought to say, not what we wished it said, but the text of the ordinance as it is. It's also important to keep in mind the structure of the ordinance. There are times when specific definitions will apply to our scenario, and we're going to use that definition. But there also might be, well, this definition is limited to just this section of the ordinance. Or for our scenario, a different definition applies because of the unique circumstance that comes into play. In some circumstances, there will be purpose and intent language. Language at the start of the ordinance will say, this is what we intend to do. This is the reason we're adopting this. This is the kind of district that we want this to be. This is the kind of use that this is intended to be. That purpose and intent language can be used to help us interpret the ordinance. But at the end of the day, purpose and intent language is just that. It's kind of fluffy, intentional language. It's the regulations that really matter. And so if the regulations are clear, that's what we have to apply. Okay. So those are, I mean, really the key to ordinance interpretation is the ordinance itself, the specific language that we've got. So let's put that into play. Let's think about that for just a minute. Here's an example scenario. Suppose this comes before the board. At the beginning of each section of the ordinance listing zoning district regulations, the purpose of the district is stated. The purpose of this particular industrial district is as follows. It is intended to permit in this district any commercial use which is not inherently obnoxious to urban areas because of the noise, odors, light, dust, or the use of dangerous materials. Under the list of uses permitted in the industrial district, we find included mixing plants of concrete or paving materials. Is an asphalt mixing plant allowed in this district? All right, so we've got a zoning district. The purpose and intent language says any commercial use is allowed here, as long as that commercial use is not inherently obnoxious to urban areas because of the noise, odors, light, dust, or the use of dangerous materials. And then in the use chart, or the list of uses, it allows for mixing plants of concrete or paving materials. Is an asphalt mixing plant allowed in this district? How do we interpret this?
I guess I would have a factual question as to how similar asphalt mixing plants are to concrete mixing plants, but given that asphalt is a paving material, I would interpret it as saying, yes, it is permitted.
Okay, John, so a good clarifying question of maybe some details about how similar is concrete to asphalt, but just from our general notion, a road driveway could be paved with concrete, driveway could be paved with asphalt, pretty similar. But I show up neighbor concerned about this permit being granted. And I say, well, look here. It says right there in the industrial district that this district is, it is intended to permit in this district any commercial use which is not inherently obnoxious to urban areas because of the noise, odors, light, dust, and use of dangerous materials. And what else is an asphalt plant other than obnoxious to urban areas because of the noise, odors, light, dust, or use of dangerous materials? How do we resolve that?
Well, I would go back to John's question of the smell of concrete being prepared is very different, in my opinion, from the odor of the asphalt being prepared. But I think to the letter of the law, we're on shaky ground if we don't approve this because it's under the use of permit. We find including mixing plants, and that's what this is, a mixing plant out in the district.
Yeah, so
and it's paving material. So I mean, I understand the neighbors' anxiety about this, but I don't think they have. They proved their point unless they can show studies that show that asphalt more toxic than concrete mixing. That would be my opinion.
yeah, so go ahead.
I would say from an interpretation perspective, you have a specific statement in the ordinance regarding the use of concrete or paving material mixing plants, and that would govern over a more general statement about intended purpose.
Yes. So we've got here some internal conflict within the ordinance, right? We've got some purpose and intent language that's saying one thing, and we've got some use regulations that are saying something else. And when we've got that kind of conflict, when we've got this kind of conflict, if the purpose and intent saying one thing, but the regulation says something else, the regulation wins. It's going to be the specific regulation that's going to control here mixing plants of concrete or paving materials. It's hard to argue how asphalt is not a mixing plant of paving materials. That is what it is. So here, that asphalt plant is going to be allowed. It is permitted, even if it is obnoxious to urban areas because of the noise, odors, lights, dust, or the use of dangerous materials. That purpose and intent language does not control over the specific regulations. Now, that one, this comes from a case in North Carolina. It's a little easier when you've got purpose and intent versus ordinance. One thing that sometimes happens is you've got ordinance versus ordinance, where one provision says you got to do A, another provision says you got to do B, and then you wind up with the conflict between those. In those situations, you might be looking at more of the structure of the ordinance. Well, which one's more specific, or which one applies specifically to this district? Is there a general statement and then a more specific statement? In that case, the more specific would control. But here, yes, on this example, just as Deborah and John indicate, we've got this conflict between the intent, the purpose language, and the regulation language. The regulation language is going to control. Asphalt plants are allowed in this district. They are a mixing plant of paving materials. Okay. One more interpretation question, and then I'm going to pause just to see about additional questions on interpretation and more broadly. So in another section of the ordinance, the text for the general business district specifically names permitted uses, including mobile home sales lots, automobile sales, used car lots, and motorcycle sales, and similar sales establishments. The highway business district specifically lists as permitted, as a permitted use, farm machinery sales. Are farm machinery sales permitted in the general business district?
I would be inclined because it says and similar sales establishments. And machinery is like cars, motorcycles. I mean, they're motorized vehicle things. So I would say yes, that it is permitted under the general business.
Okay. So there's an argument to be made based on that kind of that broad bucket at the end of that list: mobile home sales lots, automobile sales, used car lots, motorcycle sales, and similar sales establishments. Your ordinance, I bet, is full of those little phrases at the end, and similar such and such and such. So we can make an argument that that farm machinery sales are allowed under that general business district. Any argument otherwise?
Well, if I wanted to play devil's advocate, I would say that the types of sales listed in the general business district are all consumer type sales, whereas farm machinery is more of a commercial type equipment. Some argument along those lines.
To be clear, John, I was asking for you to play devil's advocate. So excellent job. So we could find some distinction here, right? I mean, we could talk about how automobile, motorcycle, that's more of consumer sales, retail sales, and farm machinery sales is different in nature, more wholesale in nature. There's some different size components and kind of qualitative differences between the different types. We might also, so I agree with that, and there is a general rule of thumb, a general interpretive guidance rule of thumb that says including a use in one place implies the exclusion of that use in another place. And so here, the Highway Business District specifically spells out farm machinery sales. It says farm machinery sales are allowed in the Highway Business District. And one rule of interpretation would say that means it's not allowed other places where it's not listed. The inclusion in one place implies the exclusion in other places. And so we could flip that around as well. We could say, well, mobile home sales lots are specifically allowed in the general business district, and that would imply that they're not allowed in other districts unless they're specifically listed. In this case, I think either way. I mean, this is one of those. That folks can look at it. Agree. Mobile homes are large in size and scale. Farm machinery is large in size and scale, and so I could argue that that farm machinery sales are similar sales establishments that should be allowed in the general business district. But I can also use that rule of thumb to say, look, farm machinery sales are specifically allowed in the highway business district. That means they're not allowed other places where they're not listed. At the end of the day, I think that's where I would fall on that one. I would say specifically allowed in the highway business district, so not allowed in the general business district. I might also look at, I was trying to do some highlighting real quick. I might also look at just the grammar here, the punctuation, the similar sales establishments right here is tacked on to motorcycle sales and similar sales establishments. There's not a semicolon there as there is up here. We've got mobile home lots, semicolon, automobile sales, semicolon, used car lots, semicolon. And then we've got the last clause there, and motorcycle sales and similar sales establishments. I might say, well, similar sales establishments to motorcycle sales would be ATV sales, maybe small watercraft sales, stuff like motorcycle sales, not large scale John Deere tractors. And so I would leave those with the highway business district. But this is the kind of detailed interpretation and drawing out differences and trying to decide that inevitably staff has to do to make decisions about whether a use is allowed or not, whether a notice of violation should go out or not. And it's the kind of interpretation and distinction that the Board of Adjustment is called on to do if and when there's an appeal of that staff decision. All right, so that is a bit of a sprint through quasi-judicial procedures, variance standards and evidence, and appeals of staff decisions. Y'all have been very patient and kind to stick with me for 3 hours of this. We've got a few minutes left, and so what I'll do is I will stop talking and I'll see if there are specific questions that you may have around appeals, variances, or just quasi-judicial decisions in general.
I have a question about the issue we were just talking about. If we made the decision to say, no, it doesn't fit, but the person who wants to appeal that, where do they appeal that to?
Great question. So not only for that appeal, but for any appeal from the Board of Adjustment, it would go to Superior Court.
Okay.
And at the Superior Court level, it would be handled similarly, where the judge would be looking at the record that you have to base your decision on, interpreting the laws that apply based on the rules of thumb, based on the definitions in the ordinance. And so there is an additional appeal beyond the Board of Adjustment. It would go to Superior Court. And then depending on the scenario, depending on the interest of the parties, it could go on to the State Court of Appeals and the State Supreme Court.
So, Deborah, let me just emphasize from the city attorney's office perspective, once you have actually made a decision in that regard and have memorialized it in writing, then that is a situation that either myself or Jill, who's also on this meeting as well, would handle going forward in regards to the briefing, the arguments, and the necessary litigation to the local Mecklenburg County Superior Court, all the way, if necessary, to the North Carolina Supreme Court. We will, brief the board if there are any issues or concerns in regards to that litigation or any outcomes or decisions from the judges, but we will handle that in normal course of business for us as your attorney.
Thank you. I was just curious.
This is a little outside the scope of the presentation, and I won't hold it against you if you don't know the answer. But I understand that representing someone in one of these quasi-judicial proceedings could constitute the unauthorized practice of law. And there's, most of the time it's just an applicant. They're representing themselves, but plenty of instances where you've got a design professional that is there talking on behalf of the applicant, or even sometimes a family member or family friend who might be, a little bit better of a public speaker will kind of, speak on behalf of the applicant. Where's that line, and what is it that we as a board need to do when that arises and you don't have a lawyer and it's not just someone talking about their own application?
Yeah, it's a great question, and I can give some context and some thoughts, but I don't have a perfect answer on it. So the state bar has an ethics decision to say that yes, the representing an individual, advocating for an individual before a quasi-judicial board is the practice of law. And so there is the potential of violations of state bar requirements and ethics for someone to act as an attorney on behalf of someone in a quasi-judicial setting if they are not a licensed lawyer in North Carolina. That said, I think there is a fair bit of room for the less formal presentation on behalf of someone where it's not making legal arguments, but it's providing the factual context of the case. And so the architect or the engineer providing, talking through the site plan and the considerations of the design. the adult child speaking on behalf of the elderly parent, not making legal arguments per se, but providing, but serving as the kind of public spokesperson for their interest. There are questions that come up with regard to corporations and nonprofits as to whether they have to have an attorney on their behalf to speak with regard to quasi-judicial decisions. I don't have a good answer on that. It's there are some boards take the approach, some communities take the approach of requiring that be legal counsel. Others say quasi-judicial is quasi-judicial, and the rules of evidence kind of apply, and the rules of court kind of apply, and we're not going to. It is a less formal setting, and we're not going to require that, especially of a small nonprofit in our community. So that's a bit of a non-answer to what is a very good question. But there's lots of different approaches to it, and there's not a real clear, direct answer. I think one thing that the real estate professionals need to be very careful about, the engineers, the realtors, the developers, they need to be careful that they are not wandering into across the line of acting as legal representation, making legal arguments on behalf of their client if they're not qualified to do so.
So Adam, I'm gonna probably throw something out that you probably already discussed, but I just want to make sure we hone in on this a little bit for the board. That personal hardship aspect that we talked about before versus this was not created by the applicant. So when we're saying the hardship is created by the ordinance versus a personal hardship, that can sometimes be a very fine line to understand and review for the board. So is there a good way to kind of help the board conceptualize like the aspect of a hardship that's created by, personal actions, which means, maybe to the extent the ordinance didn't create that, you created that, and now the ordinance has boxed you in because of something you did.
Yeah.
Versus, the ordinance created a hardship and you didn't do anything to begin with. So those two seem to be kind of like opposite ends in regards to the analysis. Personal hardship is not something considered, but hardship should be considered. How do you separate those two out?
So let me try an example and see if that gets at the question. So imagine there is scenario one is I own a lot that is triangular in nature, right? So I own a triangle lot, and because of the way that the general setbacks apply, it leaves me with very little developable land within my lot. So I could build a strange little triangle-shaped house. I could do that, but it's gonna be very small. It's gonna really limit the extent to which this property can be developed. And it's because I've got this weird triangle lot that was platted out 100 years ago, and it's just the nature, the shape of this lot. I purchased it 10 years ago. I thought it might need a variance, but I didn't do anything to change the shape of the lot. In that case, it's based off of the shape of the lot. The hardship is created by the setbacks of the ordinance. I didn't do anything. I purchased the property, sure, but I didn't do anything to cause this hardship. In that case, I think I could make a case for a variance. I need to provide my evidence. I need to show how it's unnecessary and it's different from my neighbors, but I could make a case for a variance. Contrast that with I own the lot next door, and 10 years ago, I decided to sell off a chunk of that lot that left me with this strangely configured lot. And because of the way the setbacks sit, I don't have much left to build. And I'd really like to be able to build on this lot, so shouldn't y'all give me a variance? Well, I created that strangely shaped lot. It was my own actions that caused the setbacks to be especially onerous on this property. It's a self-created hardship. I don't qualify for a variance. I can go negotiate with my neighbors to buy back some more land. I can sell this property to somebody more creative that can come up with a way to fit within the ordinance. But I created the hardship that caused this. And so I think that's an important distinction there of, is it the property as it is, or did the property undertake some action that caused this hardship to make it a self-created hardship? Now, with each of those, whether I am a fancy developer with deep pockets, or whether I am a school teacher with limited means and want to stay in the community and be a teacher in the community, but it's getting cost prohibitive. The individual who's asking for it, their ability to pay for some additional thing does not come into play. Those personal circumstances do not come into play for deciding if this lot should get a variance or not.
On the second example that you gave, where the person sold off a piece of it and now they're left with a little triangular lot, if they then sell it to some other new buyer at an arm's length transaction, is that person now kind of in a different position than the owner was that took the action? I mean, or did they step into the shoes of that prior owner and they're kind of stuck with what they had done?
So I'm going to pull back up the slide on self-created hardship. As I gave the example, I was thinking, oh man, somebody's going to ask this question and it's going to be a really good one. So good question. So we've got, for this self-created hardship limitation, the hardship did not result from actions taken by the applicant or the property owner. So I can't sell off a sliver of the property and make the setbacks wonky and then come ask for a variance. But the act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. And so the question, a great question, well, what if I caused the hardship, but then I sold it off to John in an arm's length transaction? He now has purchased the property knowing that circumstances might exist to justify granting a variance. Is he also limited from getting a variance? We don't have case law on this. This is a relatively new addition to the statutes from 5 or 6 years ago. And I haven't seen this litigated to know what the courts would do with this. There's an argument to be made that, look, if there was a third-party sale and an arm's length transaction, maybe that new person could get a variance. There's an argument to be made there. I think there's also an argument to be made, especially if it seems like that sale may have been done to try to subvert the variance standards. And there's an argument to be made that that new owner steps into the shoes of the prior owner. If the prior owner created the hardship, then that carries on, that it remains a self-created hardship. And this language here of knowledge that circumstances exist that may justify the granting of a variance. Well, if the original was self-created, then circumstances don't exist that would justify the granting of a variance. And so I think this is one that's I think you could argue either way. It really will probably depend on the facts of the circumstance. Given enough time, I could imagine we might have enough, kind of some years of distance between the self-created hardship and the new purchase that may then kind of allow for moving forward with the variance. But it's a great question that we don't really have an answer for. All right, y'all. Well, as I said, you have been kind and patient to stick with me for quasi-judicial procedures for 3 hours on this January morning. Thank y'all, as I said, for your public service, and thank you for working hard to serve the city of Charlotte. Serving on the Board of Adjustment, I suspect is thankless work, so I'll be one to thank you for your public service. I'll hand it back over to Max or Shad or whoever else needs to close us out, but thanks, y'all.
Well, thanks, Adam, for spending your morning with us. Yeah, that's great. I don't have anything else to add. If anyone else has any comments or questions, if not,
I just wanted to thank Adam. It was very informative. I learned a lot today, even though I've been on the board. You know, I felt like I was dropped in the deep end of the pool when I first came on the board. But I've learned a lot just attending meetings. But you've clarified a lot of things, and I appreciate that. Thank you.
Likewise, thank you.
all right. Well, that's it. I really appreciate it. And y'all have a great afternoon.
Thanks, Chad. Bye-bye.
Thanks.
Guys.
Thanks, Adam.
Thank you.
Thanks,
Bye.
Chad. Thanks, Adam, everybody.
Adam, are you still on?
I am. Yes.
Hi, I'm Jill Sanchez Myers. I'm going to be the new board attorney. Just joined the city attorney's office about 2 months ago. So
Great.
I wanted to know if it's okay if I occasionally reach out to you with questions.
Please do. Yeah, no, we're here as a resource for communities all across the state, and so would be glad to help to the extent we can. One of the biggest limitation is just capacity. There's kind of 2.5 of us right now that are doing law, and you may or may not have seen the new legislation around land use regulation in North Carolina and kind of the rewriting of the statutes has made us a little bit busy. So just time and capacity is the only limitation, but we'd be glad to answer questions to the extent we can.
Sure. No, I completely understand. And I started my career many years ago working for DSS. So every once in a while, reach out to Janet Mason and John Saxon, and the school government is amazing. So I appreciate all of the help over the years from your publications and trainings and phone call when urgently needed.
Yes. Well, thank you for the kind words, and we're glad to be able to do a little bit to help.
Thank you again. It was very, very good. Appreciate it.
Awesome. All right. Thanks. See y'all.